a very common question is, what is the difference between a provisional application and a non-provisional application, and which should I file? Okay, a provisional application is an informal application. I call it informal because there aren't any particular requirements for filing the provisional application. It's not examined by the patent office. It can't issue into a patent, but it's a way to get your idea on file at a minimum cost. People confuse that though with being easy. There's still a lot of legal requirements to file in that provisional application. You still have to disclose your invention in detail. Your patent application still has to be enabled. And when it's time to file the non-provisional application, you can't add any new matter. So it's very important that you get all that information you want into that provisional application. The only difference is it doesn't necessarily have to be in any particular format. It's not examined by the patent office. It's just a way to get your idea on file and say, this is my invention and this is my date of invention, before you go out and talk to people about your idea. For example, if you're trying to do your due diligence to figure out if this is something you want to do to continue on with that non-provisional process or whatnot. It's just a way to get your idea on file at the minimum cost. It's also a way, even if cost isn't an issue, you don't want to invest in the non-provisional application. You just want to put that idea on file and get some more information to figure out if this is a viable idea or product that I could take to the market and be successful with. The non-provisional application, that is the formal application. It has to be in a particular format. It is examined by the patent office. It can issue into a patent. And if you file a provisional first, and you want to maintain the date of the provisional application, you have to file that non-provisional within a year. So we understand the difference between the two. And as I said, one of the reasons you might decide to file the provisional first versus the non-provisional, a lot of my clients will decide to file the non-provisional, go straight to the non-provisional. Others will do the provisional and then in a year or earlier file the non-provisional. The provisional application is just a way to get your idea on file at the minimum cost because it doesn't require as much formality, i.e. less legal work, so the cost is a little less. And it's just a way, minimum investment to put you on the road to protection, so it gives you that time to do more due diligence before you file that non-provisional application.